Can I refer to some comments that were made by Simon Bridges that I agree with? This bill doesn't take away all rights of criminals to get compensation in some cases. We can all, at least in theory, envisage a circumstance where the state, through prison officers, could actually breach somebody's rights, and they could terribly brutalise them, or they could actually torture them, they could deprive them of their liberty. And in those sorts of situations, it is absolutely right and proper that prisoners, bad people though they have been, should have rights so as to guard against the state acting like that as a curb against inappropriate actions on the part of the state. And it would be wrong for this Parliament to take away all of the rights of prisoners in such a case. And, you know, if we look, for example, at some of the things that happened during World War II and where people were imprisoned and treated abominably, of course those people ought to have had their human rights upheld. And so if their human rights are abused, then it's appropriate that they have legal remedies through New Zealand courts. So I agree with Simon Bridges that that is appropriate. What the bill did, or the original what the original act did, and what this bill now extends to a later date, says, well, that's well and good, but when that criminal has harmed someone else, and that other person may have had a reparation order that's not paid, or may have had a right to take a civil action against the prisoner and get some form of compensation, but didn't or couldn't because the person was broke, and it was like getting blood from a stone. There was no likelihood of legal recourse, so why would they waste their time and effort on making a claim against that person in prison? Because of the change in circumstance as a consequence of a compensation award in favour of the prisoner, we need to preserve that money so that the victim of that prisoner's crime can have the ability to make a claim against that prisoner and effectively attach that claim to the money that's otherwise going to be paid out to the prisoner. And that's, of course, very appropriate. I think everyone, or just about everyone in this House, would agree that we should, whilst not taking all rights away from the criminal in the case of that prisoner who might be abused, rare though those cases are, we do need to say that where that compensation is paid to the prisoner, and let's not forget, they've got high tests before they would get any compensation. They're not people that, people aren't going to have sympathy for prisoners. It has to be a pretty gross violation of their rights before they get any compensation. But even in that case, it's important that we preserve the sum of money where appropriate, so that someone who'd been injured by that prisoner who had a right of compensation or reparation can have recourse to that money that would otherwise go to the prisoner. And that's the balance that this legislation sought to achieve. And indeed, if we had gone further and had banned completely any right of compensation, we would be going a step too far, and we would be in breach of various United Nations conventions, and we would be doing something that would be wrong. Beg your pardon? Drip. What do you mean? This legislation does get the balance right. Can I respond to some of the suggestions that were made earlier trying to defend the government's record in respect of victims' compensation? Compensation for victim and treatment of victims in New Zealand largely relies upon the accident compensation system in terms of the counselling that they get following a traumatic injury. And nowhere is that more true than in respect of people who have suffered sexual crimes. Sexual crimes leave the victim of that crime often in a depressed state. Their life can fall to bits. They can have trouble, particularly if the person who abused them was a family member. They can have problems in terms of keeping or making good and strong personal relationships in their life. And I don't think there's many people in this country don't think that the victims of sexual crimes should have access to proper counselling. They most definitely should. And yet this government, through Dr Smith, as Minister of ACC, has overseen a huge decrease in the approval of people for counselling. So marked is it that on a year-by-year comparison, 300 claims were approved the prior year, compared with 6 this year. 300 compared with 6. That's more than 95% decrease in approval rate. And I don't think that makes sense. I think anyone can see that something has gone seriously wrong. This was pointed out to the Minister last year, that this was seriously wrong. It was pointed out by the opposition, the Labour opposition. It was pointed out by the psychotherapists and the psychologists. It was pointed out by the Massey University academics whose work Dr. Smith was purporting to rely upon, but which they say he has misused, or that ACC has misused under his supervision. And that the Minister now turns around and says, oh, we've got to have some sort of inquiry to see what's gone wrong here, without just restoring the prior status quo until it's fixed, is adding insult to injury on the part of those mainly women who have been abused and cannot now get counselling in New Zealand. And I think that is disgraceful, to be perfectly frank. I think the very least that the government and the Minister could have done was say, we've got this wrong, we're going to restore the status quo while we sort it out. But instead he's hiding behind process. He's hiding behind process. He's not willing to admit fault, notwithstanding the fact that the approval rate's gone down from 300 a month to, I think it was in February, 6. The facts speak for themselves. There are more than 200 women in that month alone who are suffering the effects of sexual crimes without any counselling. Counselling sessions generally cost around $100 or more per session, and most of those women who have been abused, who have been the victims of some horrendous sexual crimes, cannot afford that, and they have no avenue through which they can get counselling at present. And the government is not addressing it. All Dr. Smith says, oh, we're going to have a review, when we know patently that the first and foremost thing that should be being done is returning to the prior system while they sort it out, instead of persisting with this new system, which, as I said in February, had only 6 approvals for counselling through the whole of New Zealand. And we think New Zealand is such a perfect society that there are only 6 out of those 300-odd applications were worthy. Are we saying that those other 294 women were lying? Are we really saying that they had some sort of pre-existing mental illness, which meant that they deserved what happened to them? Are we saying that they should not get treatment? So, I really do take issue with some of the comments that have been made by the National Party in this debate. They raised the issue of ACC and trying to say how well they're doing for the victims of crime, when this is actually the real situation in these most damaged people in respect of victims of violent sexual crimes. They are getting no help whatsoever. Returning to the Prisoners and Victims Claim Expiring Application Dates Amendment Bill, we support this bill. Thank you.
I call Paul.